Question 1. Scenario. Ms. Lisa Rodriguez lives in California and is a social worker who counsels undocumented immigrants. The state of California recently passed a law that requires social workers to report the immigration status of their clients to federal authorities. Ms. Rodriguez believes this law violates the undocumented immigrant's Fourth Amendment right to privacy. Question. Under the doctrine of federalism, which of the following is the most likely outcome if Ms. Rodriguez challenges this law in court? A. The California law will be upheld because immigration is a federal power. B. The California law will be struck down because it violates undocumented immigrants' fundamental rights. C. The court will apply a balancing test to determine if the state's interest outweighs the privacy concerns. D. The court will likely dismiss the case for lack of standing. Correct answer. C. The court will apply a balancing test to determine if the state's interest outweighs the privacy concerns. Explanation. The 14th Amendment Due Process Clause incorporates certain fundamental rights from the Bill of Rights, including the Fourth Amendment right to privacy, against the states. However, states also have a legitimate interest in regulating various aspects of life within their borders. The Supreme Court has developed a balancing test to determine the constitutionality of state laws that may infringe on fundamental rights. This test weighs the nature of the right at stake against the state's interest in enforcing the law. Cruzan v. Missouri, 497 U.S. 539, 1990. In this scenario, the court will likely apply this balancing test to determine if California's interest in enforcing immigration laws outweighs the undocumented immigrants' privacy concerns. Question 2. Question 2. Scenario. Mr. David Thompson lives in New York and is a political activist who is very critical of the governor's policies. He frequently posts his criticisms on social media using strong language and satire. The governor, feeling personally attacked, directs the state police to monitor Mr. Thompson's social media activity. Question. Under the First Amendment, can the New York State Police monitor Mr. Thompson's social media activity based solely on his criticism of the governor? A. Yes, because the governor has a right to protect his reputation. B. Yes, because the monitoring does not prevent Mr. Thompson from speaking freely. C. No, because such monitoring chills Mr. Thompson's First Amendment right to free speech. D. No, because the First Amendment only protects political speech. Correct answer. C. No, because such monitoring chills Mr. Thompson's First Amendment right to free speech. Explanation. The First Amendment protects freedom of speech, which includes the right to criticize government officials. The Supreme Court has recognized that government monitoring of individuals' speech can have a chilling effect, even if it does not directly prevent them from speaking. Lamont v. Postmaster General, 383 U.S. 363, 1965. In this scenario, the governor's directive to monitor Mr. Thompson's social media activity solely based on his criticism is likely to be seen as a violation of Mr. Thompson's First Amendment rights. Question 3. Question 3. Scenario. The state of Texas has a long history of capital punishment. Recently, a new method of execution has been proposed that some argue is less cruel and unusual than the current method. Opponents of the death penalty have filed a lawsuit challenging the constitutionality of capital punishment altogether. Question. Which of the following is the most accurate statement regarding the legal standard the Supreme Court will likely use when reviewing this case? A. The court will apply strict scrutiny and strike down the death penalty as a violation of the Eighth Amendment. B. The court will presume the death penalty is constitutional and require opponents to prove otherwise. C. The court will balance the state's interest in punishment against the potential for cruel and unusual punishment. D. The court will defer to the state's judgment on the appropriate form of punishment. Correct answer. C. The court will balance the state's interest in punishment against the potential for cruel and unusual punishment. Explanation. The Eighth Amendment prohibits cruel and unusual punishment. However, the Supreme Court has not adopted a bright-line rule on the death penalty. Instead, the court uses a proportionality test, balancing the state's interest in retribution and deterrence against the severity of the punishment. Gregg v. Georgia, 428 U.S. 153, 1976. In this scenario, the court will likely apply this proportionality test to determine whether the death penalty, even under the new method, constitutes cruel and unusual punishment. Question 4. Scenario: Ms. Sarah Jones lives in Florida and is a high school teacher. She wants to wear a religious headscarf to school but is concerned about a recent state law that prohibits public school teachers from wearing any religious garb. Question: Under the First Amendment's Free Exercise Clause, can the Florida law prohibiting religious garb for teachers be upheld? A. Yes, because the government has a compelling interest in maintaining secularism in public schools. B. Yes, because the law applies to all religious symbols, not just Ms. Jones' headscarf. C. No, because the law imposes an undue burden on Ms. Jones' free exercise of religion. D. No, because the First Amendment requires public schools to promote religion. Correct answer: C. No, because the law imposes an undue burden on Ms. Jones' free exercise of religion. Explanation: The Free Exercise Clause protects the right to practice one's religion freely. However, this right is not absolute. The government can restrict religious practices if it has a compelling interest in doing so, and the restriction is narrowly tailored to achieve that interest. Sherbert v. Verner, 374 U.S. 398, 1963. In this scenario, the court will likely balance Ms. Jones' right to wear a headscarf against the state's interest in maintaining secularism in public schools. If the law can be achieved through less restrictive means, such as allowing religious garb but prohibiting proselytizing, then it may be found to violate the Free Exercise Clause. Question 5. Question 5. Scenario: The state of Illinois enacted a law requiring all residents to register their firearms with the state within 30 days. Mr. Michael Lee, a resident of Illinois, believes this law violates his Second Amendment right to keep and bear arms. Question: How will the Supreme Court likely analyze Mr. Lee's challenge to the Illinois gun registration law under the Second Amendment? A. The court will apply strict scrutiny and likely strike down the law. B. The court will presume the law is constitutional and require Mr. Lee to prove it significantly burdens his Second Amendment rights. C. The court will uphold the law if it is rationally related to a legitimate government interest. D. The Second Amendment only protects the right to own guns for use in a militia. Correct answer: B. The court will presume the law is constitutional and require Mr. Lee to prove it significantly burdens his Second Amendment rights. Model answer rule: The Supreme Court has developed a two-part test for analyzing Second Amendment challenges. First, the court determines whether the law regulates firearms in a core Second Amendment area, such as the right to possess a firearm for self-defense at home. Second, if the law does regulate a core Second Amendment right, the court applies a two-pronged test to determine its constitutionality. The court will presume the law is constitutional and require the challenger to show that 1. The regulation is not consistent with the nation's historical tradition of firearm regulation, and 2. The government interest underlying the law cannot be achieved through less restrictive means. District of Columbia v. Heller, 554 U.S. 570, 2008. Explanation: In this scenario, the Supreme Court is likely to apply the two-part test outlined in District of Columbia v. Heller. The court will first determine whether gun registration falls within a core Second Amendment right. If so, the court will then require Mr. Lee to demonstrate that the law is not consistent with historical tradition and that the government's interest in registration cannot be achieved through less restrictive means. Question 6. Scenario: The state of Nevada has a unicameral legislature, meaning it has only one house. A group of citizens in Nevada believe a bicameral legislature, with two houses, is a fundamental principle of a representative democracy and that Nevada's unicameral system violates the Equal Protection Clause of the 14th Amendment. Question: is the group's claim likely to succeed? A. Yes, because the Equal Protection Clause requires all states to have a bicameral legislature. B. Yes, because a unicameral legislature inherently discriminates against certain groups of voters. C. No, because the structure of a state legislature is not subject to strict scrutiny under the Equal Protection Clause. D. No, because the 14th Amendment only applies to the federal government. Correct answer: C. No, because the structure of a state legislature is not subject to strict scrutiny under the Equal Protection Clause. Explanation: the Equal Protection Clause requires states to treat all similarly situated people equally. However, the Supreme Court has generally given states wide latitude in structuring their governments, including their legislatures. This is known as the rational basis test, which applies to matters of state governance that do not involve fundamental rights or suspect classifications. Lowe v. Salisbury and Morehouseville R.R. Company, 174 U.S. 67, 1899. Question 7. Scenario: Ms. Olivia Rodriguez is a citizen of the United States who was born in Mexico. She has lived in California since she was a child. Ms. Rodriguez is denied in-state tuition at a California public university because of her immigration status. Question: under the 14th Amendment's Privileges or Immunities Clause, can California deny Ms. Rodriguez in-state tuition? A. Yes, because the Privileges or Immunities Clause only applies to citizens born in the United States. B. Yes, because states have broad discretion in setting tuition rates for public universities. C. No, because denying in-state tuition to Ms. Rodriguez discriminates against her based on her national origin. D. No, because the Privileges or Immunities Clause guarantees Ms. Rodriguez all the benefits of citizenship. Correct answer: B. Yes, because states have broad discretion in setting tuition rates for public universities. Explanation: the Privileges or Immunities Clause of the 14th Amendment protects certain fundamental rights that are shared by all U.S. citizens. However, the Supreme Court has interpreted this clause narrowly and has not found it to apply to in-state tuition for public universities. In this scenario, Ms. Rodriguez's challenge would likely be analyzed under the Equal Protection Clause, which requires states to treat all similarly situated people equally. Question 8. Question 8. Scenario: the state of Wyoming passed a law that bans all abortions after 20 weeks of pregnancy, with no exceptions for rape or incest. A women's health organization files a lawsuit challenging the law on the grounds that it violates a woman's right to privacy under the 14th Amendment. Question: how will the Supreme Court likely analyze this challenge? A. The court will apply strict scrutiny and likely strike down the law. B. The court will presume the law is constitutional and require the health organization to prove it imposes an undue burden on women's access to abortion. C. The court will defer to the state's judgment on regulating abortion. D. The 14th Amendment does not protect a right to abortion. Correct answer: B. The court will presume the law is constitutional and require the health organization to prove it imposes an undue burden on women's access to abortion. Explanation: the Supreme Court's landmark decisions in Roe v. Wade, 1973, and Planned Parenthood v. Casey, 1992, established a woman's right to abortion under the 14th Amendment's right to privacy. However, the court also recognized that states have a legitimate interest in protecting potential life. The court has developed an undue burden test to balance these competing interests. Under this test, a state regulation on abortion is unconstitutional if it imposes an undue burden on a woman's ability to obtain an abortion before viability, around 24 weeks. In this scenario, the court will likely apply the undue burden test to determine whether the 20-week abortion ban violates a woman's right to privacy. Question 9. Scenario. The federal government passes a law that requires all Americans to attend a citizenship ceremony upon reaching the age of 18. The ceremony would involve reciting a Pledge of Allegiance and learning about American history and government. Mr. William Lee believes this law violates his First Amendment right to free speech and free association. Question. Is Mr. Lee's challenge likely to succeed? A. Yes, because the First Amendment protects the right to refuse to participate in patriotic exercises. B. Yes, because the government cannot compel individuals to express specific beliefs. C. No, because the government has a compelling interest in promoting national unity. D. No, because the First Amendment only protects speech directed at the government. Correct answer. B. Yes, because the government cannot compel individuals to express specific beliefs. Explanation. The First Amendment protects freedom of speech and freedom of association. This includes the right to refuse to participate in symbolic acts, even those associated with patriotism. In West Virginia State Board of Education v. Barnett, 1943, the Supreme Court held that students could not be compelled to salute the American flag. In this scenario, Mr. Lee's argument that the compelled citizenship ceremony violates his right to free speech by forcing him to express specific beliefs is likely to be given serious consideration by the court. Question 10. Scenario. The state of Alaska enacted a law that allows warrantless searches of all vehicles entering the state. The stated purpose of the law is to combat the illegal drug trade. A group of truck drivers challenged the law, arguing it violates the Fourth Amendment's protection against unreasonable searches and seizures. Question. How will the Supreme Court likely analyze the truck drivers' challenge? A. The court will apply strict scrutiny and likely strike down the law. B. The court will presume the law is constitutional as long as the state has a legitimate purpose. C. The court will balance the state's interest in fighting crime against the intrusion on individual privacy. D. The Fourth Amendment only protects searches within the United States. Correct answer. C. The court will balance the state's interest in fighting crime against the intrusion on individual privacy. Explanation. The Fourth Amendment protects individuals from unreasonable searches and seizures. The Supreme Court has developed a balancing test to determine the reasonableness of a search. This test weighs the nature of the intrusion on the individual's privacy against the government's interest in conducting the search. Ferguson v. City of Gloucester, 557 U.S. 1, 2009. In this scenario, the court will likely consider the pervasiveness of the warrantless searches applied to all vehicles and the availability of less intrusive methods for drug interdiction. Question 11. Question 11. Scenario. Ms. Ana Garcia is a lawyer who represents a controversial political activist. Ms. Garcia receives a subpoena from a federal grand jury investigating the activist. The subpoena requires Ms. Garcia to turn over all communications she has had with the activist. Ms. Garcia believes this violates the attorney-client privilege, which protects confidential communications between lawyers and their clients. Question. Can the government compel Ms. Garcia to turn over her communications with the activist? A. Yes, because the government's interest in investigating crimes outweighs the attorney-client privilege. B. Yes, because the attorney-client privilege only applies to criminal cases. C. No, because the attorney-client privilege is a fundamental right under the Sixth Amendment. D. No, because the government must show a compelling need to overcome the attorney-client privilege. Correct answer. D. No, because the government must show a compelling need to overcome the attorney-client privilege. Explanation. The attorney-client privilege is a long-recognized legal principle that protects confidential communications between lawyers and their clients. This privilege is essential for ensuring that clients can fully disclose information to their lawyers and receive effective legal representation. The Supreme Court has recognized the attorney-client privilege and held that the government must show a compelling need to overcome it. Fisher v. United States, 428 U.S. 40, 1976. In this scenario, the government would likely need to demonstrate that the information sought from Ms. Garcia is essential to the investigation and cannot be obtained from any other source. Question 12. Scenario: the federal government passes a law that bans all political donations from corporations. Ms. Elizabeth Brown, the CEO of a large corporation, believes this law violates the First Amendment's right to freedom of speech. Question: is Ms. Brown's challenge likely to succeed? A. Yes, because the First Amendment protects all forms of speech, including corporate speech. B. Yes, because the government cannot restrict political speech without a compelling reason. C. No, because the government has a legitimate interest in preventing corruption in campaign finance. D. No, because the First Amendment only protects the speech of natural persons. Correct answer: C. No, because the government has a legitimate interest in preventing corruption in campaign finance. Explanation: the Supreme Court has recognized that corporations have certain First Amendment rights, including the right to free speech. However, the court has also balanced this right against the government's interest in regulating campaign finance to prevent corruption. In Citizens United v. Federal Election Commission, 2010, the court held that the government could not prohibit corporations from independent expenditures on elections. However, the court also acknowledged the government's interest in preventing quid pro quo corruption and upheld disclosure requirements for corporate campaign spending. In this scenario, the court would likely consider the balance between Ms. Brown's First Amendment rights and the government's interest in preventing corruption in campaign finance. Question 13. Scenario: the state of Maine has a long history of allowing prayer in public schools. Parents of several students in the Maine public school system object to the practice of teacher-led prayer and are suing to have it stopped. Question: under the Establishment Clause of the First Amendment, can the public schools in Maine continue to allow teacher-led prayer? A. Yes, because the Establishment Clause only prohibits government from endorsing a particular religion. B. Yes, because prayer is a historical tradition in American public schools. C. No, because teacher-led prayer is inherently coercive and violates students' right to free exercise of religion. D. No, because the Establishment Clause requires public schools to be completely secular. Correct answer: C. No, because teacher-led prayer is inherently coercive and violates students' right to free exercise of religion. Explanation: the Establishment Clause of the First Amendment prohibits the government from establishing a state religion or favoring one religion over another. The Supreme Court has interpreted this clause to limit the role of religion in public schools. While the court has allowed for moments of silence for reflection, it has struck down practices like teacher-led prayer because they create a risk of coercion and pressure students to participate in a religious activity. Lee v. Weissman, 505 U.S. 575, 1992. Question 14. Scenario: Mr. David Hernandez is a legal resident alien living in Texas. He is arrested for shoplifting and wants to contact the Mexican consulate to seek assistance. However, the police department in Texas has a policy of denying arrested individuals consular notification unless they are specifically from a country with a reciprocity agreement with the United States. Mexico does not have such an agreement. Question: does Mr. Hernandez have a right to consular notification under the Vienna Convention on Consular Relations, VCCR? A. Yes, because the VCCR is a self-executing treaty that grants all arrested aliens consular notification rights. B. Yes, because Mr. Hernandez, as a legal resident alien, enjoys the same rights as U.S. citizens under the 14th Amendment. C. No, because the VCCR only applies to countries with reciprocity agreements with the United States. D. No, because the VCCR only applies to consular officials, not arrested aliens. Correct answer: A. Yes, because the VCCR is a self-executing treaty that grants all arrested aliens consular notification rights. Explanation. The Vienna Convention on Consular Relations, VCCR, is an international treaty ratified by the United States. Article 36 of the VCCR requires a detaining state to notify the consulate of the arrested individual's home country without delay, absent exceptional circumstances. The Supreme Court has held that the VCCR is self-executing, meaning it does not require further legislation to be enforceable in domestic courts. Breard v. Green, 523 U.S. 740, 1998. In this scenario, Mr. Hernandez has a right to consular notification under the VCCR, regardless of the lack of a reciprocity agreement between the United States and Mexico. Question 15. Question 15. Scenario. The state of Hawaii enacts a law that bans all hate speech, defined as speech that attacks a person or group on the basis of attributes such as race, religion, ethnic origin, national origin, sex, disability, sexual orientation, or gender identity. A group of political activists challenges the law, arguing it violates the First Amendment's protection for free speech. Question. Is the Hawaii law likely to be upheld? A. Yes, because the government has a compelling interest in preventing hate crimes. B. Yes, because the law only restricts a narrow category of unprotected speech. C. No, because the First Amendment protects all speech, even offensive speech. D. No, because the law is too vague and could be used to suppress unpopular viewpoints. Correct answer. D. No, because the law is too vague and could be used to suppress unpopular viewpoints. Explanation. The First Amendment protects a wide range of speech, even offensive speech. However, the Supreme Court has recognized certain categories of unprotected speech, such as fighting words or incitement to imminent lawless action. Hate speech laws are often challenged on the grounds that they are too vague and could be used to chill protected speech. In this scenario, the Hawaii law's definition of hate speech is likely to be challenged for being overly broad and potentially encompassing protected expression. The court would likely consider the vagueness of the law and its potential chilling effect on free speech before determining its constitutionality. Question 16. Scenario. The state of Montana requires all candidates for state office to disclose their tax returns. Ms. Sarah Jackson, a candidate for governor, believes this requirement violates her right to privacy. Question. Under the Fourth Amendment, can Montana require Ms. Jackson to disclose her tax returns? A. Yes, because the Fourth Amendment only protects individuals from unreasonable searches and seizures of physical property. B. Yes, because candidates for public office have a diminished expectation of privacy. C. No, because the Fourth Amendment protects all financial information. D. No, because Montana has not shown a compelling need for this disclosure requirement. Correct answer. B. Yes, because candidates for public office have a diminished expectation of privacy. Explanation. The Fourth Amendment protects individuals from unreasonable searches and seizures. However, the Supreme Court has recognized that candidates for public office have a diminished expectation of privacy due to the public's interest in their qualifications and potential conflicts of interest. Nixon v. Administrator of General Services, 403 U.S. 424, 1977. In this scenario, the court would likely balance Ms. Jackson's privacy interests against the state's interest in informing voters and preventing corruption. The disclosure requirement is more likely to be upheld if it is narrowly tailored and serves a legitimate governmental purpose. Question 17. Scenario. The federal government passes a law that makes it a crime to possess certain types of video games deemed too violent. A video game retailer association challenges the law, arguing it violates the First Amendment's protection for freedom of expression. Question. How will the Supreme Court likely analyze the challenge to the video game violence law? A. The court will apply strict scrutiny and likely strike down the law. B. The court will presume the law is constitutional and require the Video Game Association to prove it has no legitimate purpose. C. The court will balance the government's interest in protecting children from violence against the expressive content of video games. D. The First Amendment only protects speech directed at the government. Correct answer, C. The court will balance the government's interest in protecting children from violence against the expressive content of video games. Explanation. The First Amendment protects a wide range of expression, including video games. However, the Supreme Court has recognized that some forms of expression, such as obscenity, may be subject to regulation. The court has developed a balancing test to determine when government regulation of expression is permissible. This test weighs the nature of the expression against the government's interest in regulating it. Miller v. California, 413 U.S. 15, 1973. In this scenario, the court would likely consider the expressive content of video games and the potential for harm to children before determining whether the video game violence law violates the First Amendment. Question 18. Scenario. The state of South Carolina has a law that prohibits same-sex marriage. A same-sex couple living in South Carolina sues the state, arguing that the law violates their right to marry under the 14th Amendment's Equal Protection Clause. Question. How will the Supreme Court likely analyze the challenge to South Carolina's same-sex marriage ban? A. The court will apply strict scrutiny and likely strike down the law. B. The court will presume the law is constitutional and require the couple to prove it is not rationally related to a legitimate government purpose. C. The court will defer to the state's definition of marriage. D. The 14th Amendment does not apply to marriage rights. Correct answer, A. The court will apply strict scrutiny and likely strike down the law. Explanation. The 14th Amendment's Equal Protection Clause requires states to treat all similarly situated people equally. In United States v. Windsor, 2013, and Obergefell v. Hodges, 2015, the Supreme Court held that same-sex couples have a fundamental right to marry under the 14th Amendment. The court applied strict scrutiny to these cases, requiring states to show a compelling justification for denying same-sex couples the right to marry. In this scenario, the court would likely find that South Carolina's same-sex marriage ban fails strict scrutiny and violates the Equal Protection Clause. Question 19. Scenario. The federal government establishes a new national identification card system. All U.S. citizens are required to obtain a national ID card, which will contain personal information such as name, address, and social security number. A group of privacy advocates challenge the program, arguing it violates the Fourth Amendment's protection against unreasonable searches and seizures. Question. Is the National ID Card program likely to be upheld? A. Yes, because the government has a compelling interest in national security. B. Yes, because the program does not involve a physical search. C. No, because the program creates a mandatory database of personal information. D. No, because the Fourth Amendment only protects individuals from searches of their homes. Correct answer. C. No, because the program creates a mandatory database of personal information. Explanation. The Fourth Amendment protects individuals from unreasonable searches and seizures. While the Supreme Court has not definitively addressed mandatory national ID programs, the creation of a large database of personal information raises privacy concerns. The court has recognized that the government's collection of personal data can constitute a search under the Fourth Amendment, Smith v. Maryland, 469 U.S. 785, 1985. In this scenario, the court would likely balance the government's interest in national security against the potential privacy intrusion caused by the National ID Card program. The program's scope, data security measures, and the specific information collected would all be factors considered by the court. Question 20. Scenario. The state of Wyoming enacts a law that makes it a crime to possess more than 2 marijuana plants, even for personal use. Mr. David Blake, a medical marijuana user who grows his own plants, is arrested for violating this law. Question: under the Supremacy Clause of the Constitution, can Wyoming enforce its law against Mr. Blake? A. Yes, because states have the authority to regulate marijuana within their borders. B. Yes, because Mr. Blake's medical marijuana use is not protected by federal law. C. No, because the Supremacy Clause preempts any state laws that conflict with federal law regarding marijuana. D. No, because Wyoming's law violates Mr. Blake's right to privacy under the 14th Amendment. Correct answer: A. Yes, because states have the authority to regulate marijuana within their borders. Explanation: the Supremacy Clause of the Constitution establishes that federal law is the supreme law of the land and trumps conflicting state laws. However, there are areas where both federal and state governments have authority, known as concurrent powers. Marijuana regulation is generally considered a concurrent power. While the federal government has classified marijuana as a Schedule I controlled substance, it has also taken steps to allow states to implement medical marijuana programs. In this scenario, Wyoming's law restricting marijuana possession is not necessarily preempted by federal law. However, Mr. Blake could potentially challenge the law based on his status as a medical marijuana user and argue that Wyoming's law conflicts with federal policy on medical marijuana. Question 21. Scenario: the federal government passes a law that requires all Americans to participate in a mandatory national service program upon reaching the age of 18. The program would involve 2 years of service in various fields, such as the military, education, or environmental conservation. A group of young adults challenge the law, arguing it violates their 13th Amendment right against involuntary servitude. Question: is the mandatory national service program likely to be upheld? A. Yes, because the government has a compelling interest in national security. B. Yes, because the 13th Amendment only prohibits slavery and involuntary servitude as punishment for a crime. C. No, because the program forces individuals to work without their consent. D. No, because the 13th Amendment only applies to the federal government. Correct answer: C. No, because the program forces individuals to work without their consent. Explanation: the 13th Amendment prohibits slavery and involuntary servitude except as a punishment for a crime. The Supreme Court has interpreted this amendment to apply to forced labor imposed by the government. In this scenario, the mandatory national service program would likely be challenged on the grounds that it compels individuals to work without their consent. The court would likely consider the nature of the program, the availability of voluntary alternatives, and the potential for coercion before determining whether it violates the 13th Amendment. Question 22. Scenario: the city of Los Angeles enacts a law that bans all overnight camping in public spaces. A group of homeless individuals living in Los Angeles challenge the law, arguing it violates their 8th Amendment right against cruel and unusual punishment. Question: can the Los Angeles anti-camping law be enforced against the homeless population? A. Yes, because the 8th Amendment only protects individuals who are incarcerated. B. Yes, because the government has a legitimate interest in regulating public spaces. C. No, because the law criminalizes the status of being homeless. D. No, because the law does not provide adequate alternative shelter for the homeless population. Correct answer: D. No, because the law does not provide adequate alternative shelter for the homeless population. Explanation: the 8th Amendment prohibits cruel and unusual punishment. While it applies most directly to criminal punishments, the Supreme Court has recognized that the 8th Amendment can also apply in some non-criminal contexts. In City of Los Angeles v. Martinez, 2019, the court held that a similar anti-camping law could not be enforced against homeless individuals if the government did not provide adequate alternative shelter. The court reasoned that criminalizing sleeping in public spaces, when no alternative shelter is available, constitutes cruel and unusual punishment. Question 23. Scenario: the President issues an executive order directing the National Security Agency, NSA, to conduct warrantless surveillance on all electronic communications within the United States. A civil liberties organization challenges the executive order, arguing it violates the Fourth Amendment's protection against unreasonable searches and seizures. Question: is the President's executive order likely to be upheld? A. Yes, because the President has broad authority over national security matters. B. Yes, because the warrant requirement does not apply to electronic communications. C. No, because the Fourth Amendment requires a warrant for most government surveillance. D. No, because the President cannot unilaterally create new laws through executive orders. Correct answer: C. No, because the Fourth Amendment requires a warrant for most government surveillance. Explanation: the Fourth Amendment protects individuals from unreasonable searches and seizures. The Supreme Court has held that government surveillance of electronic communications can constitute a search under the Fourth Amendment, Katz v. United States, 389 U.S. 347, 1967. While the government may have a legitimate interest in national security surveillance, the court has also recognized the need for judicial oversight. In this scenario, the Civil Liberties Organization would likely argue that the President's executive order violates the Fourth Amendment by authorizing warrantless surveillance on a massive scale. The court would likely consider the balance between national security interests and individual privacy rights before determining the constitutionality of the executive order. Question 24. Scenario: a state legislature passes a law that grants immunity from civil lawsuits to all government officials. A group of citizens injured by the negligence of a state trooper sues the trooper for damages, but the trooper invokes the new immunity law as a defense. Question: does the state law granting immunity to all government officials violate the 14th Amendment's Due Process Clause? A. Yes, because the Due Process Clause guarantees a right to sue government officials. B. Yes, because the law grants absolute immunity, which is unfair to injured citizens. C. No, because states have sovereign immunity and can decide when their officials can be sued. D. No, because the Due Process Clause only protects individuals from deprivations of life, liberty, or property by the federal government. Correct answer: B. Yes, because the law grants absolute immunity, which is unfair to injured citizens. Explanation: the 14th Amendment's Due Process Clause generally prohibits states from depriving individuals of life, liberty, or property without due process of law. While states have some discretion in granting immunity to government officials, the Supreme Court has held that absolute immunity is only appropriate in very limited circumstances. In this scenario, the grant of absolute immunity to all government officials, regardless of their actions, is likely to be found to violate the Due Process Clause because it denies injured citizens a meaningful opportunity to vindicate their rights. Question 25. Scenario: a federal law prohibits the interstate transportation of child pornography. A bookstore owner is arrested for selling a book that contains images of child pornography. The bookstore owner argues that the law violates his First Amendment right to freedom of speech. Question: is the federal law likely to be upheld? A. Yes, because child pornography is not protected speech. B. Yes, because the government has a compelling interest in protecting children. C. No, because the law restricts the sale of a book, which is a protected form of expression. D. No, because the law regulates interstate commerce, not speech. Correct answer: A. Yes, because child pornography is not protected speech. Explanation: The First Amendment protects a wide range of speech, but it does not protect all speech. Child pornography is a category of speech that is not protected by the First Amendment. The Supreme Court has recognized that the government has a compelling interest in protecting children from harm, and this interest justifies prohibiting the production and distribution of child pornography. New York v. Ferber, 458 U.S. 747, 1982. Question 26. Scenario: the Environmental Protection Agency, EPA, issues a regulation limiting air pollution emissions from factories. A group of factory owners challenge the regulation, arguing that it is an overreach of the EPA's authority and violates the 10th Amendment's principle of federalism. Question: is the EPA regulation likely to be upheld? A. Yes, because the federal government has the power to regulate interstate commerce, which includes air pollution that crosses state lines. B. Yes, because the Clean Air Act grants the EPA broad authority to regulate air pollution. C. No, because the 10th Amendment reserves the power to regulate environmental issues to the states. D. No, because the regulation imposes a financial burden on businesses. Correct answer: A. Yes, because the federal government has the power to regulate interstate commerce, which includes air pollution that crosses state lines. Explanation: the Constitution grants the federal government the power to regulate interstate commerce. Air pollution can travel across state lines, and the federal government has the authority to regulate it under the Commerce Clause. Additionally, Congress has passed the Clean Air Act, which specifically authorizes the EPA to regulate air pollution emissions. In this scenario, the EPA regulation is likely to be upheld because it falls within the scope of Congress's authority to regulate interstate commerce and is consistent with the Clean Air Act. Question 27. Scenario: a major social media platform removes a user's post for violating its terms of service, which prohibit hate speech. The user sues the social media platform, arguing that it is a common carrier and cannot censor users' content. Question: does the First Amendment prevent social media platforms from moderating content on their platforms? A. Yes, because social media platforms are considered common carriers and must allow all speech. B. Yes, because removing the user's post violates their right to freedom of expression. C. No, because social media platforms are private entities and can set their own rules for content. D. No, because the First Amendment only applies to government censorship. Correct answer: C. No, because social media platforms are private entities and can set their own rules for content. Explanation: the First Amendment protects freedom of speech, but it generally only applies to government censorship. Social media platforms are private companies and have the right to set their own terms of service regarding what content is allowed on their platforms. This means they can remove posts that violate their terms, including hate speech or other harmful content. Question 28. Scenario: the state of California enacts a law that requires background checks for all ammunition purchases. A gun rights group challenges the law, arguing it violates the Second Amendment's right to bear arms. Question: is the California law requiring background checks for ammunition purchases likely to be upheld? A. Yes, because the Second Amendment only protects the right to own guns, not ammunition. B. Yes, because the government has a compelling interest in reducing gun violence. C. No, because the law imposes a burden on the right to bear arms. D. No, because the Second Amendment only applies to federal laws. Correct answer: B. Yes, because the government has a compelling interest in reducing gun violence. Explanation: the Second Amendment protects the right to keep and bear arms. The Supreme Court has recognized this right as an individual right, but it has also acknowledged that the government can regulate firearms in certain ways. In this scenario, the court would likely balance the Second Amendment right to bear arms against the government's interest in reducing gun violence. The outcome would depend on the specifics of the law and how significantly it burdens the right to bear arms. Question 29. Scenario: a public university enforces a policy that prohibits all political speech on campus except in designated free speech zones. A student group challenges the policy, arguing it violates their First Amendment right to freedom of speech. Question: is the public university's policy likely to be upheld? A. Yes, because the university has a legitimate interest in maintaining order on campus. B. Yes, because the designated free speech zones provide an adequate forum for expression. C. No, because the First Amendment protects all forms of political speech on a public university campus. D. No, because the policy creates a viewpoint-based restriction on speech. Correct answer: D. No, because the policy creates a viewpoint-based restriction on speech. Explanation: public universities are considered government actors, and the First Amendment applies to their actions. While universities have some interest in regulating speech on campus to maintain order, the Supreme Court has generally held that students at public universities have a broad right to free speech. In this scenario, the policy's creation of designated free speech zones likely restricts speech in a viewpoint-based manner and would be difficult for the university to justify. Question 30. Scenario: the federal government passes a law that makes it a crime to possess any genetically modified organisms, GMOs. A group of farmers who grow GMO crops challenge the law, arguing it violates their right to due process under the 14th Amendment. Question: does the federal law banning GMOs violate the Due Process Clause of the 14th Amendment? A. Yes, because the law takes away the farmer's property without compensation. B. Yes, because the law is too vague and fails to give fair notice of what is prohibited. C. No, because the government has a legitimate interest in regulating food safety. D. No, because the Due Process Clause only applies to criminal procedures. Correct answer: B. Yes, because the law is too vague and fails to give fair notice of what is prohibited. Explanation: the Due Process Clause of the 14th Amendment prohibits the government from depriving individuals of life, liberty, or property without due process of law. This includes the concept of fair notice, which means that laws must be clear and specific enough to give people fair warning of what conduct is prohibited. In this scenario, a complete ban on GMOs could be challenged on the grounds that it is vague and fails to provide farmers with fair notice of what is considered a crime. Question 31. Scenario: a state law requires all doctors to perform a certain medical procedure, even if they have religious objections to doing so. A doctor sues the state, arguing that the law violates their First Amendment right to free exercise of religion. Question: can the state compel a doctor to perform a medical procedure if they have religious objections? A. Yes, because the state has a compelling interest in protecting public health. B. Yes, because doctors have a professional duty to follow the law. C. No, because the First Amendment protects the free exercise of religion. D. No, because the doctor can simply refer the patient to another doctor. Correct answer: C. No, because the First Amendment protects the free exercise of religion. Explanation: the First Amendment protects the free exercise of religion. However, the government can sometimes restrict religious practices if it has a compelling interest in doing so, and the restriction is the least restrictive means of achieving that interest. In this scenario, the doctor would likely argue that the state law substantially burdens their religious beliefs. The court would balance the doctor's religious liberty against the state's interest in ensuring access to healthcare and determine if there are alternative ways to achieve that interest without forcing the doctor to perform the procedure. Question 32. Scenario: Congress passes a law that grants a copyright extension to all existing copyrights for an additional 20 years. A group of authors challenge the law, arguing it violates the Copyright Clause of the Constitution, which gives Congress limited power to grant copyrights. Question: is the law granting a blanket copyright extension likely to be upheld? A. Yes, because Congress has broad power to regulate copyrights. B. Yes, because the law benefits authors by extending their copyrights. C. No, because the Copyright Clause only allows Congress to grant copyrights for a limited time. D. No, because the law does not promote the progress of science and the useful arts. Correct answer: C. No, because the Copyright Clause only allows Congress to grant copyrights for a limited time. Explanation: the Constitution grants Congress the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This clause limits the duration of copyrights. While Congress has some discretion in setting the length of copyright terms, a blanket extension for existing copyrights could be challenged on the grounds that it violates the limited time requirement. Question 33. Scenario: Ms. Lisa Jackson, a resident of California, is a devout follower of Hinduism. Her employer, a large tech company headquartered in California, has a mandatory policy requiring all employees to participate in a week-long retreat focused on team-building exercises and company culture. The retreat includes yoga and meditation sessions that incorporate Hindu religious symbolism and chanting. Ms. Jackson feels pressured to participate in the retreat but is uncomfortable with the religious aspects of the program due to her own religious beliefs. Question: under the California Fair Employment and Housing Act, FEHA, can Ms. Jackson be compelled to participate in the company retreat if she objects on religious grounds? A. Yes, because the retreat is voluntary and Ms. Jackson is not being forced to convert religions. B. Yes, because the company retreat is a core aspect of company culture and essential for employee development. C. No, Ms. Jackson can likely request a reasonable accommodation to excuse her from the religious aspects of the retreat, such as offering alternative team-building activities. D. No, Ms. Jackson can refuse to participate in the entire retreat if she has a sincere religious objection. Correct answer: C. No, Ms. Jackson can likely request a reasonable accommodation to excuse her from the religious aspects of the retreat, such as offering alternative team-building activities. Explanation: the California Fair Employment and Housing Act, FEHA, prohibits employers from discriminating against employees on the basis of religion. This includes creating a hostile work environment through religious coercion. In this scenario, the mandatory retreat program that incorporates religious symbolism could be seen as pressuring Ms. Jackson to participate in religious activities that conflict with her own beliefs. However, employers are also required to accommodate sincere religious beliefs unless doing so would cause undue hardship to the company. Ms. Jackson requesting to be excused from the religious aspects of the retreat, while still participating in the core team-building activities, is likely a reasonable accommodation that the employer should consider under FEHA. Question 34. Scenario: the state of Texas enacts a law that bans all abortions after 6 weeks of pregnancy, with no exceptions for rape or incest. A women's rights organization challenges the law, arguing it violates a woman's right to privacy under the 14th Amendment's Due Process Clause. Question: how is the Supreme Court likely to analyze the Texas law in light of the precedent set in Roe v. Wade and Planned Parenthood v. Casey? A. The court will likely uphold the Texas law because it regulates abortion after the point of viability. B. The court will likely overturn Roe and Casey entirely, allowing states to ban abortion at any stage of pregnancy. C. The court will likely strike down the Texas law because it creates an undue burden on a woman's right to choose abortion before viability. D. The court will likely remand the case for further consideration without issuing a clear standard for abortion restrictions. Correct answer. C. The court will likely strike down the Texas law because it creates an undue burden on a woman's right to choose abortion before viability. Explanation. The Supreme Court's precedents in Roe v. Wade, 1973, and Planned Parenthood v. Casey, 1992, established a woman's right to abortion under the 14th Amendment's Due Process Clause. This right is not absolute, however, and states can regulate abortion after the point of viability, when the fetus becomes capable of surviving outside the womb. The key question is whether a particular restriction creates an undue burden on a woman's right to choose abortion before viability. In this scenario, a complete ban on abortion after 6 weeks, with no exceptions for rape or incest, would likely be found to be an undue burden under the existing precedent. The court may grapple with how to balance the woman's right to privacy with the state's interest in protecting potential life, but a complete ban at such an early stage of pregnancy is unlikely to be upheld. Question 35. Scenario. Mr. Rodriguez, a resident of New York City, is a legal gun owner. A new city ordinance prohibits the possession of all semi-automatic rifles within city limits. Mr. Rodriguez argues that the ordinance violates his Second Amendment right to keep and bear arms. Question. How will the Supreme Court likely analyze the New York City ordinance under the Second Amendment? A. The court will likely strike down the ordinance entirely, as the Second Amendment guarantees an individual right to own any type of firearm. B. The court will likely uphold the ordinance if the government can show a compelling interest in reducing gun violence within the city. C. The court will apply a two-part test, considering whether the ordinance is consistent with historical traditions of gun regulation and whether it is substantially related to a legitimate government interest. D. The court will defer to the city's judgment on gun control measures, as long as there is a rational basis for the ordinance. Correct answer. C. The court will apply a two-part test, considering whether the ordinance is consistent with historical traditions of gun regulation and whether it is substantially related to a legitimate government interest. Explanation. The Second Amendment right to keep and bear arms is an individual right that applies to state and local governments through the 14th Amendment. However, the Supreme Court has recognized that this right is not unlimited and that the government can regulate firearms in certain ways. In District of Columbia v. Heller, 2008, the court established a two-part test for analyzing gun control laws. The first part asks whether the regulation is consistent with the historical tradition of gun regulation in the United States. The second part asks whether the regulation is substantially related to a legitimate government interest, such as reducing gun violence. In this scenario, the court would likely apply this two-part test to the New York City ordinance. The ordinance's compatibility with historical gun regulations and its effectiveness in reducing gun violence would be key factors in the court's decision. Question 36. Scenario. A state law in Florida requires all public schools to display a banner in each classroom that reads, "In God We Trust." A group of parents with children in public schools object to the mandatory banner requirement, arguing it violates the Establishment Clause of the First Amendment. Question. Is the Florida law requiring the display of "In God We Trust" banners in public schools likely to be upheld? A. Yes, because the motto, "In God We Trust," is not inherently religious and has a secular purpose. B. Yes, because the government has a legitimate interest in promoting moral values in public schools. C. No, because the display of a religious motto in public schools constitutes government endorsement of religion. D. No, because the Establishment Clause only applies to the federal government, not state governments. Correct answer. C. No, because the display of a religious motto in public schools constitutes government endorsement of religion. Explanation. The First Amendment's Establishment Clause prohibits the government from establishing a state religion or favoring one religion over another. Courts have interpreted this clause to prevent government actions that endorse or promote religion in public schools. In this scenario, the display of "In God We Trust" banners in every classroom is likely to be seen as a form of government endorsement of religion. even though the motto also appears on U.S. currency. The Supreme Court has struck down similar practices in the past, such as mandatory school prayer. Question 37. Scenario: the federal government passes a law that denies citizenship to all undocumented immigrants who entered the country illegally. Immigrant rights groups challenge the law, arguing it violates the 14th Amendment's Equal Protection Clause. Question: can Congress deny citizenship to all undocumented immigrants through a blanket statutory rule? A. Yes, because Congress has broad power over immigration policy under the Constitution. B. Yes, because undocumented immigrants are not entitled to the same rights as citizens. C. No, because the Equal Protection Clause requires that the law be rationally related to a legitimate government interest. D. No, because the 14th Amendment guarantees a path to citizenship for all immigrants. Correct answer: C. No, because the Equal Protection Clause requires that the law be rationally related to a legitimate government interest. Explanation: the 14th Amendment's Equal Protection Clause requires that the government treat similarly situated individuals in a similar way. While Congress has broad power to regulate immigration, this power is not unlimited. The Supreme Court has held that immigration laws must be rationally related to a legitimate government interest. In this scenario, a blanket denial of citizenship to all undocumented immigrants would likely be challenged on the grounds that it is not rationally related to any specific government interest. The court might allow for some classifications based on factors such as the time an immigrant has spent in the country or their criminal history, but a complete bar on citizenship for all undocumented immigrants is unlikely to be upheld. Question 38. Scenario: Ms. Davis, a high school student in Virginia, is suspended from school for expressing her political views on social media during her free time outside of school grounds. The views she expressed were critical of the school administration. Ms. Davis argues that the suspension violates her First Amendment right to free speech. Question: can a public school suspend a student for expressing their political views on social media outside of school grounds? A. Yes, because schools have a legitimate interest in maintaining order and preventing disruption. B. Yes, if the student's speech is offensive or harassing towards other students or teachers. C. No, because a student's First Amendment rights extend beyond the school setting. D. No, unless the student's speech creates a substantial disruption to the school environment. Correct answer: D. No, unless the student's speech creates a substantial disruption to the school environment. Explanation: the First Amendment protects the right to free speech, even for students in public schools. However, this right is not absolute. Schools have a legitimate interest in maintaining order and preventing disruption within the school environment. The Supreme Court has established a balancing test in this context. In Tinker v. Des Moines Independent Community School District, 1969, the court held that student speech can be restricted if it causes a substantial disruption to the school environment or interferes with the rights of others. In this scenario, Ms. Davis's speech occurred outside of school and did not directly disrupt the school environment. The school administration would likely need to show a substantial connection between her speech and potential disruption within the school to justify the suspension. Question 39. Scenario: the state of California enacts a law that requires all candidates for state office to disclose their tax returns to the public. A group of politicians challenge the law, arguing it violates their right to privacy under the 14th Amendment. Right to privacy. It's important to note that the right to privacy is not explicitly mentioned in the Constitution but has been recognized by the Supreme Court through various rulings. Question: can California require all candidates for state office to disclose their tax returns to the public? A. Yes, because voters have a right to know about the financial situation of potential office holders. B. Yes, because the disclosure requirement is narrowly tailored to promote a compelling government interest. C. No, because the law is an unreasonable invasion of the candidate's right to privacy. D. No, because there is no federal law requiring such disclosure for state elections. Correct answer. B. Yes, because the disclosure requirement is narrowly tailored to promote a compelling government interest. Explanation. The 14th Amendment's Due Process Clause has been interpreted to protect certain enumerated rights, including a right to privacy. However, this right is not absolute and can be balanced against other important interests. In this scenario, the disclosure of tax returns could be seen as an invasion of the candidate's privacy. However, the state also has a compelling interest in informing voters about the financial situation of those seeking public office. The court would likely weigh these competing interests and consider whether the disclosure requirement is narrowly tailored to achieve the government's interest. If the disclosure requirement is deemed essential for informing voters without being overly broad, it could be upheld. Question 40. Scenario. The federal government passes a law that creates a national voter registration system. All eligible voters would be automatically registered to vote based on data collected from government agencies. Opponents of the law argue it violates the National Voter Registration Act, NVRA, which requires states to maintain their own voter registration systems. Question. Does the federal law creating a national voter registration system violate the National Voter Registration Act, NVRA? A. Yes, because the NVRA gives states exclusive control over voter registration. B. Yes, because the national system would likely lead to voter fraud. C. No, because Congress has the power to regulate federal elections under the Constitution. D. No, because the national system would still allow states to maintain some control over voter registration. Correct answer. C. No, because Congress has the power to regulate federal elections under the Constitution. Explanation. The Constitution grants Congress the power to regulate federal elections. The National Voter Registration Act, NVRA, itself was enacted under this power. While the NVRA establishes a framework for voter registration and requires states to offer voter registration opportunities, it does not necessarily give states exclusive control over the entire process. In this scenario, the federal government's creation of a national voter registration system could be challenged on the grounds that it conflicts with the existing framework established by the NVRA. However, Congress's broad power to regulate federal elections would be a strong argument in favor of the national system, as long as it does not completely eliminate the state's role in voter registration. Question 41. Scenario. The President signs an executive order that expands the scope of a federal agency, the Environmental Protection Agency, EPA, to regulate greenhouse gas emissions from individual cars and trucks. Several car manufacturers challenge the executive order, arguing that the President has exceeded his authority and that Congress has the primary power to regulate such matters. Question. Can the President regulate greenhouse gas emissions from individual cars and trucks through an executive order? A. Yes, because the President has inherent authority to address environmental concerns. B. Yes, because the executive order interprets existing EPA regulations. C. No, because Congress has the primary power to regulate commerce under the Constitution, which includes car emissions. D. No, because any regulations on car emissions must go through the formal rulemaking process. Correct answer. C. No, because Congress has the primary power to regulate commerce under the Constitution, which includes car emissions. Explanation. The Constitution grants Congress the power to regulate commerce with foreign nations, and among the several states, and with the Indian tribes. This power, known as the Commerce Clause, gives Congress broad authority to regulate economic activity. In this scenario, the regulation of greenhouse gas emissions from cars and trucks would likely be considered an aspect of interstate commerce. While the President has some executive power, it cannot override the legislative power of Congress. The car manufacturers would likely argue that regulating car emissions is a matter best left to Congress through the legislative process, not through unilateral executive action. Question 42. Scenario: a state law prohibits same-sex couples from marrying within the state. A gay couple who wish to marry challenge the law, arguing it violates the 14th Amendment's Equal Protection Clause. Question: is the state law prohibiting same-sex marriage likely to be upheld after the Supreme Court's decision in Obergefell v. Hodges, 2015? A. Yes, because states have the right to define marriage within their borders. B. Yes, because marriage is a religious institution and the government should not regulate it. C. No, because the Supreme Court's decision in Obergefell v. Hodges established a nationwide right to same-sex marriage. D. No, because the Equal Protection Clause requires states to treat all citizens equally. Correct answer: C. No, because the Supreme Court's decision in Obergefell v. Hodges established a nationwide right to same-sex marriage. Explanation: in Obergefell v. Hodges, 2015, the Supreme Court held that the 14th Amendment's Equal Protection Clause guarantees a right to same-sex marriage. This decision overturned previous rulings that allowed states to ban same-sex marriage. Therefore, the state law in this scenario would be unlikely to be upheld after Obergefell. Question 43. Scenario: a city council enacts a law that prohibits all panhandling within the city limits. A homeless advocacy group challenges the law, arguing it violates the 8th Amendment's prohibition on cruel and unusual punishment. Question: can a city enforce a law that prohibits all panhandling within the city limits against homeless individuals? A. Yes, because panhandling can be disruptive and harassing to pedestrians. B. Yes, because the city has a legitimate interest in regulating public spaces. C. No, because the 8th Amendment's protection against cruel and unusual punishment applies to criminal punishments, not civil regulations. D. No, because a complete ban on panhandling may burden a homeless person's ability to access basic necessities. Correct answer: D. No, because a complete ban on panhandling may burden a homeless person's ability to access basic necessities. Explanation: the 8th Amendment's prohibition on cruel and unusual punishment applies to criminal punishments, not to civil regulations. However, courts have sometimes interpreted the 14th Amendment's Due Process Clause to limit the government's power to impose burdens on fundamental rights. In this scenario, the homeless advocacy group might argue that panhandling is a form of expressive conduct protected by the First Amendment and that a complete ban on panhandling burdens a homeless person's ability to communicate their need for assistance and violates their 14th Amendment right to due process. The court would likely balance the city's interest in regulating public spaces against the potential burdens placed on homeless individuals. Question 44. Scenario: Ms. Lee, a resident of Illinois, works for a private company as a social media manager. She wears a religious headscarf as part of her faith. The company has a dress code policy that prohibits employees from wearing any head coverings other than hard hats for safety reasons. Ms. Lee requests a religious accommodation to allow her to wear her headscarf, but the company denies the request. Question: under Title VII of the Civil Rights Act of 1964, can Ms. Lee be denied a religious accommodation to wear her headscarf at work? A. Yes, because the company has a legitimate safety reason for enforcing its dress code policy. B. Yes, because Ms. Lee is not required to wear a headscarf as a fundamental tenet of her religion. C. No, Ms. Lee can likely request a reasonable accommodation from the company's dress code policy. D. No, Title VII only applies to discrimination based on race. Correct answer: C. No, Title VII only applies to discrimination based on race. Explanation: Title VII of the Civil Rights Act of 1964 prohibits employers from discriminating against employees on the basis of religion. This includes refusing to provide reasonable accommodations for sincerely held religious beliefs, unless doing so would cause undue hardship to the employer. In this scenario, Ms. Lee's request to wear a headscarf as part of her religious practice would likely be considered a religious accommodation under Title VII. The company would have to show that the accommodation would cause undue hardship, such as compromising workplace safety or creating a conflict with a uniform policy essential to the company's image. If no such hardship exists, Ms. Lee's employer would likely be required to accommodate her religious practice. Question 45. Scenario: the state of Texas enacts a law that allows concealed carry permit holders to bring their firearms onto college campuses. A group of students and faculty members challenge the law, arguing it violates their Second Amendment right to feel safe at school. Question: can the Second Amendment right to bear arms extend to carrying firearms on college campuses? A. Yes, because the Second Amendment guarantees an individual right to carry a firearm anywhere they choose. B. Yes, because concealed carry permit holders are responsible gun owners who pose no threat to campus safety. C. No, because colleges and universities have a compelling interest in maintaining a safe learning environment. D. No, because the Second Amendment only applies to the federal government, not state governments. Correct answer: C. No, because colleges and universities have a compelling interest in maintaining a safe learning environment. Explanation: the Second Amendment right to keep and bear arms is an individual right that applies to state and local governments through the 14th Amendment. However, the Supreme Court has recognized that this right is not unlimited and that the government can regulate firearms in certain ways. In this scenario, the question is whether allowing concealed carry on college campuses is consistent with the Second Amendment. Colleges and universities have a strong interest in maintaining a safe learning environment for students and faculty. The court would likely balance this interest against the right to bear arms and consider factors such as the effectiveness of alternative security measures on campus. While the Second Amendment protects the right to bear arms, it does not necessarily guarantee the right to carry them everywhere, especially in sensitive locations like college campuses. Question 46. Scenario: a federal law prohibits all online gambling websites from operating within the United States. Several states that have legalized and regulated online gambling within their borders challenge the law, arguing it violates the 10th Amendment's principle of federalism. Question: can the federal government completely ban online gambling nationwide, even in states that have legalized it? A. Yes, because Congress has the power to regulate interstate commerce, which includes online gambling. B. Yes, because online gambling can be a source of crime and Congress has the power to regulate morality. C. No, because the 10th Amendment reserves certain powers to the states, and gambling regulation is traditionally a state matter. D. No, because the federal government cannot regulate activities that have already been legalized by individual states. Correct answer: A. Yes, because Congress has the power to regulate interstate commerce, which includes online gambling. Explanation: the 10th Amendment reserves certain powers to the states and the people, but it also grants Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. This power, known as the Commerce Clause, gives Congress broad authority to regulate economic activity. Online gambling can be seen as a form of interstate commerce, especially if it involves transactions across state lines. In this scenario, the federal government's argument would likely be based on its power to regulate commerce. The states challenging the law would argue that gambling regulation has traditionally been a matter of state control under the 10th Amendment. The court would need to weigh these competing interests and determine whether the federal government's interest in regulating online gambling outweigh. Question 47. Scenario: Ms. Rodriguez, a citizen of the United States, is arrested for protesting against the war in a public park. The park has a long-standing rule that prohibits any demonstrations or speeches without a permit. Ms. Rodriguez did not obtain a permit before protesting. Question: can the government arrest Ms. Rodriguez for protesting in the park without a permit? A. Yes, because the government has a legitimate interest in maintaining order in public spaces. B. Yes, because Ms. Rodriguez violated the park's established rule regarding permits. C. No, because Ms. Rodriguez's right to free speech under the First Amendment likely outweighs the government's interest in requiring a permit for protests. D. No, because the government cannot restrict peaceful protests in a public forum. Correct answer: C. No, because Ms. Rodriguez's right to free speech under the First Amendment likely outweighs the government's interest in requiring a permit for protests. Explanation: the First Amendment protects the right to freedom of speech, which includes the right to protest. However, this right is not absolute. The government can impose reasonable time, place, and manner restrictions on speech in order to maintain order and protect the rights of others. In this scenario, the park likely qualifies as a public forum, where the government's ability to restrict speech is more limited. While the government has a legitimate interest in regulating public spaces, requiring a permit for all protests in a public park may be seen as an unreasonable restriction on free speech. Ms. Rodriguez could argue that the permit requirement creates a prior restraint on speech, potentially chilling protected First Amendment activity. Question 48. Scenario: the federal government passes a law that grants immunity from prosecution to all government officials for any actions taken while in office. A group of citizens challenges the law, arguing it violates the principle of checks and balances within the government. Question: can the federal government grant immunity from prosecution to all government officials for any actions taken while in office? A. Yes, because the Constitution grants broad immunity to government officials. B. Yes, because the law is necessary to protect officials from frivolous lawsuits. C. No, because absolute immunity would violate the principle of checks and balances and create an unaccountable government. D. No, because the federal government cannot interfere with the state's criminal justice systems. Correct answer: C. No, because absolute immunity would violate the principle of checks and balances and create an unaccountable government. Explanation: the Constitution does grant some immunity to government officials, but it is not absolute. The principle of checks and balances is essential to a functioning democracy, and government officials must be accountable for their actions. In this scenario, a law granting absolute immunity from prosecution would likely be found to violate this principle. While officials may be entitled to qualified immunity for certain actions taken in good faith, absolute immunity would remove any incentive for officials to act lawfully. Question 49. Scenario: Mr. Jackson, a resident of California, is a freelance web developer. He refuses to create websites for same-sex wedding ceremonies based on his religious beliefs. A same-sex couple who wanted to hire Mr. Jackson for their wedding website design sue him for discrimination, arguing it violates California's Unruh Civil Rights Act, which prohibits discrimination based on sexual orientation in public accommodations. Question: can Mr. Jackson use his religious beliefs as a defense against the discrimination lawsuit based on California's Unruh Civil Rights Act? A. Yes, because the First Amendment protects Mr. Jackson's right to free exercise of religion. B. Yes, because Mr. Jackson is a freelance web developer, not a public accommodation. C. No, because California's Unruh Civil Rights Act prohibits discrimination in public accommodations, and wedding services are a protected category. D. No, because Mr. Jackson's religious beliefs do not justify discrimination against a protected class. Correct answer: C. No, because California's Unruh Civil Rights Act prohibits discrimination in public accommodations, and wedding services are a protected category. Explanation: The First Amendment protects the free exercise of religion, but this right is not absolute. Courts have recognized that religious beliefs can sometimes conflict with anti-discrimination laws. In this scenario, California's Unruh Civil Rights Act clearly prohibits discrimination based on sexual orientation in public accommodations. Wedding services are likely to be considered a form of public accommodation under the law. Mr. Jackson's religious beliefs may allow him to object to same-sex marriage personally, but they may not necessarily justify refusing to provide professional services to a same-sex couple. The court would likely weigh Mr. Jackson's religious freedom against the couple's right to be free from discrimination in the marketplace. California has a strong interest in enforcing its anti-discrimination laws, and Mr. Jackson may have difficulty establishing that his religious beliefs compel him to refuse service in this case. Question 50. Scenario: a federal law mandates life imprisonment without the possibility of parole for all individuals convicted of a third-time drug offense. A group of criminal justice reform advocates challenge the law, arguing it is cruel and unusual punishment in violation of the Eighth Amendment. Question: does a mandatory life sentence without parole for a third-time drug offense constitute cruel and unusual punishment under the Eighth Amendment? A. Yes, because any life sentence for a nonviolent crime is inherently cruel and unusual. B. Yes, because the punishment is disproportionate to the severity of the crime. C. No, because the Eighth Amendment only applies to torture and other barbaric punishments. D. No, because Congress has the power to define criminal offenses and their punishments. Correct answer: B. Yes, because the punishment is disproportionate to the severity of the crime. Explanation: the Eighth Amendment prohibits cruel and unusual punishment. While this amendment does not completely eliminate the death penalty, the Supreme Court has interpreted it to limit the types of punishment that can be imposed. In this scenario, the court would consider whether a mandatory life sentence without parole for a third-time drug offense, which is a nonviolent crime, is so disproportionate to the severity of the crime that it violates the Eighth Amendment. The court has previously struck down mandatory life sentences for juvenile offenders, finding them to be cruel and unusual punishment. The outcome in this case would likely depend on the specific factors considered by the court, such as the potential for rehabilitation and the severity of the drug offenses involved. Question 51. Scenario: a city council enacts a law that bans all pit bulls within city limits. Dog owners who own pit bulls challenge the law, arguing it violates due process under the 14th Amendment. Question: can a city council enact a law that bans all pit bulls within city limits, regardless of the temperament of the individual dog? A. Yes, because the government has a legitimate interest in protecting public safety from dangerous dogs. B. No, because the law is a form of unfair punishment directed at a specific breed of dog. C. No, because the 14th Amendment's Due Process Clause requires the government to provide notice and an opportunity to be heard before depriving someone of property. D. No, because the Due Process Clause prohibits the government from taking property without just compensation. Correct answer: B. No, because the law is a form of unfair punishment directed at a specific breed of dog. Explanation: the 14th Amendment's Due Process Clause protects individuals from arbitrary government action. While the government has a legitimate interest in protecting public safety, it cannot enact laws that are so broad or unfair that they violate due process. In this scenario, a complete ban on all pit bulls, regardless of the temperament of the individual dog, could be seen as an unfair punishment directed at a specific breed. The law might be considered arbitrary and not narrowly tailored to address the problem of dangerous dogs. Owners of pit bulls who can demonstrate their dogs are not a threat to public safety could argue that the ban violates their due process rights. Question 52. Scenario: a public high school enforces a policy that prohibits students from wearing clothing or accessories that depict the Confederate flag. A student challenges the policy, arguing it violates their First Amendment right to freedom of expression. Question: Can a public school restrict students from wearing clothing or accessories that depict the Confederate flag? A. Yes, because the Confederate flag is a symbol of hate speech and racism. B. Yes, because public schools have a legitimate interest in maintaining a positive learning environment free from disruption. C. No, because the clothing is not causing a substantial disruption and the First Amendment protects symbolic speech. D. No, because the First Amendment only protects speech directed at the government. Correct answer. B. Yes, because public schools have a legitimate interest in maintaining a positive learning environment free from disruption. Explanation. The First Amendment protects freedom of expression, but this right is not absolute in the context of public schools. Schools have a legitimate interest in maintaining order and a positive learning environment for all students. In this scenario, the Confederate flag is a symbol with a long and complex history tied to slavery and racial oppression. While the student has the right to express their views, the school could argue that allowing Confederate flag imagery disrupts the learning environment for many students, especially black students. The court would likely balance the student's right to symbolic speech with the school's interest in fostering an inclusive learning environment. Question 53. Scenario. A city council passes a law that makes it a crime to sleep in public places. Homeless advocates challenge the law, arguing it violates the Eighth Amendment's protection against cruel and unusual punishment. Question. Can a city enforce a law that criminalizes sleeping in public places against homeless individuals? A. Yes, because the city has a legitimate interest in regulating public spaces. B. Yes, because criminalizing public sleeping discourages homelessness. C. No, because the Eighth Amendment prohibits criminalizing the status of being homeless. D. No, because the law does not provide homeless individuals with alternative shelter options. Correct answer. D. No, because the law does not provide homeless individuals with alternative shelter options. Explanation. The Eighth Amendment's protection against cruel and unusual punishment applies not only to physical punishments but also to certain conditions of confinement. In this scenario, criminalizing sleeping in public places, especially if there are no adequate alternative shelter options available for homeless individuals, could be seen as cruel and unusual punishment. The court might consider factors such as the severity of the penalty, the climate, and the availability of alternative shelter before upholding the law. Question 54. Scenario. A federal law grants copyright protection to all original works of authorship for 120 years after the death of the author. A group of artists and creators argue that this term is excessively long and stifles creativity by limiting access to older works. Question. Can Congress set a copyright term of 120 years after the death of the author? A. Yes, because Congress has the power under the Constitution to grant copyrights and patents. B. No, because such a long copyright term violates the First Amendment right to freedom of expression. C. No, because the copyright term should be limited to a shorter period to encourage new creative works. Correct answer. A. Yes, because Congress has the power under the Constitution to grant copyrights and patents. Explanation. The Constitution grants Congress the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This clause is the basis for copyright law in the United States. In this scenario, while there is debate about the optimal length of copyright terms, Congress has the authority to set the duration. However, opponents of the long copyright term argue that it hinders creativity by making it difficult or expensive to obtain permission to use older works. The question of how long is too long for a copyright term is a complex legal and policy issue. Question 55. Scenario. A state law requires all students in public elementary schools to participate in daily prayers before classes begin. Parents of a non-religious student challenge the law, arguing it violates the Establishment Clause of the First Amendment. Question: can a state law require all students in public elementary schools to participate in daily prayers before classes begin? A. Yes, because prayer is a historical tradition in American schools. B. Yes, because the prayers are non-denominational and do not promote any one religion. C. No, because the Establishment Clause prohibits the government from endorsing religion in public schools. D. No, because the law does not allow students to opt out of prayer. Correct answer: C. No, because the Establishment Clause prohibits the government from endorsing religion in public schools. Explanation: the First Amendment's Establishment Clause prohibits the government from establishing a state religion or favoring one religion over another. Courts have interpreted this clause to prevent the government from promoting religion in public schools. In this scenario, requiring all students to participate in daily prayers, even if non-denominational, would likely be seen as an endorsement of religion by the state. Students, especially those from non-religious families, may feel pressured to participate even if they hold different beliefs. The law would likely be struck down as a violation of the Establishment Clause. Question 56. Scenario: a federal law prohibits the possession of any illegal drugs, including small amounts of marijuana for personal use. A group of individuals challenge the law, arguing that it violates their right to privacy under the 14th Amendment's Due Process Clause. They argue that possessing a small amount of marijuana for personal use in their own homes is a private activity that should not be criminalized by the government. Question: can the government criminalize the possession of a small amount of marijuana for personal use in private homes? A. Yes, because the government has a legitimate interest in controlling the use of illegal drugs. B. No, because the 14th Amendment's Due Process Clause protects a right to privacy that encompasses personal drug use in the home. C. Yes, because Congress has the power to regulate interstate commerce, and marijuana use can have an impact on interstate commerce. D. No, but the government can regulate the possession of marijuana for personal use if it can demonstrate a substantial government interest. Correct answer: B. This is a complex legal issue and the answer may depend on the specific circumstances. The Supreme Court has issued rulings upholding the enforceability of mandatory arbitration agreements in some employment contexts. In this scenario, the question is whether forcing employees to agree to arbitration as a condition of employment is fair and violates their right to access the court system. While arbitration can be faster and cheaper, it may also limit worker protections and remedies available in court. The court would likely balance the competing interests of employers and employees in deciding the validity of the law. Question 57. Scenario: Ms. Lisa Rodriguez, a resident of California, is a passionate environmental activist. She plans to participate in a protest against a proposed oil pipeline construction project on federal land within California. The Federal Bureau of Land Management, BLM, has issued a permit for the project, but Ms. Rodriguez and other activists believe the project will have a devastating environmental impact. The BLM regulation for protests on federal land requires a permit application to be submitted 30 days in advance, specifying the number of participants, the time, duration, and location of the protest. Ms. Rodriguez believes this permitting process is an unreasonable restriction on her First Amendment right to freedom of speech and freedom of assembly. Question: can the Bureau of Land Management, BLM, require a permit application 30 days in advance for protests on federal land, specifying the number of participants, the time, duration, and location of the protest? A. Yes, because the BLM has a legitimate interest in managing public lands and ensuring public safety during protests. B. No, because the First Amendment right to freedom of speech and assembly guarantees absolute protection for all protests on government property. C. No, because the 30-day application requirement is an unreasonable restriction on the First Amendment rights of protesters. D. Yes, because protests on federal land are not protected by the First Amendment. Correct answer. D. Yes, because protests on federal land are not protected by the First Amendment. Explanation. The 14th Amendment's Due Process Clause protects certain enumerated rights, including a right to privacy. This right to privacy is not absolute, but it can limit the government's authority to regulate certain private conduct. In this scenario, the question is whether the government's interest in controlling illegal drugs outweighs the individual's right to privacy in their own home. The Supreme Court has not definitively addressed the issue of marijuana possession and the right to privacy. However, the court has recognized a zone of privacy in the home in cases such as Griswold v. Connecticut, 1965, right to privacy regarding contraception, and Roe v. Wade, 1973, right to privacy regarding abortion. Lower courts have reached different conclusions on the issue of marijuana possession and privacy. The outcome of this case would likely depend on the specific details of the law and the court's balancing test. The government would argue that marijuana use can have negative consequences, even if limited to personal use in the home. Opponents of the law would argue that the government has no legitimate interest in regulating private conduct within the home, especially for a relatively minor offense. Question 58. Scenario. Mr. Henry Thompson, a resident of Florida, is a lawyer who frequently represents clients on death row. He is a vocal critic of the capital punishment system and has spoken out publicly against his state's use of the death penalty. Mr. Thompson is informed by the Florida Bar Association that they are initiating disciplinary proceedings against him for his anti-death penalty advocacy. The Bar Association argues that Mr. Thompson's public statements about capital punishment are unprofessional and undermine public confidence in the justice system. Question. Can the Florida Bar Association discipline Mr. Thompson for his public advocacy against the death penalty? A. Yes, because the Bar Association has a legitimate interest in regulating the professional conduct of lawyers. B. No, because Mr. Thompson's speech is protected by the First Amendment's guarantee of freedom of speech. C. Yes, because Mr. Thompson's advocacy could be seen as prejudicial to his clients facing the death penalty. D. No, because the First Amendment only protects speech directed at the government. Correct answer. B. No, because Mr. Thompson's speech is protected by the First Amendment's guarantee of freedom of speech. Explanation. The First Amendment protects freedom of speech, and this right extends to lawyers. Lawyers can express their personal views on political and social issues, even if those views are controversial. In this scenario, Mr. Thompson's public opposition to the death penalty is protected speech. The Florida Bar Association would likely have difficulty demonstrating that his advocacy undermines his ability to represent his clients competently. The Supreme Court case NAACP v. Button, 1963, established that lawyers have the right to speak out on public issues, even if their speech is critical of the government or the legal system. The court recognized that freedom of speech is essential for a healthy democracy and that lawyers play a vital role in advocating for reform. However, the Florida Bar Association may have some regulatory authority over Mr. Thompson's speech if it can be shown that his statements are directly related to a specific case he is handling and could prejudice the outcome of that case. Question 59. Scenario. A state law in Texas prohibits same-sex couples from marrying within the state. A gay couple residing in Texas, Ms. Sarah Jones and Ms. Emily Wilson, want to get married but are unable to do so due to the state law. They sue the state, arguing that the law violates their 14th Amendment right to equal protection under the law. Question. Can a state law prohibit same-sex couples from marrying within the state? A. Yes, because states have the right to define marriage within their borders. B. No, because the 14th Amendment's Equal Protection Clause guarantees equal access to marriage for all citizens. C. Yes, because marriage is a religious institution and states can regulate religious matters. D. No, but the state can require same-sex couples to undergo additional premarital counseling. Correct answer. B. No, because the 14th Amendment's Equal Protection Clause guarantees equal access to marriage for all citizens. Explanation. The 14th Amendment's Equal Protection Clause requires states to treat all citizens equally under the law. In 2015, the landmark Supreme Court case Obergefell v. Hodges established that the right to marry is a fundamental right guaranteed by the 14th Amendment and that this right extends to same-sex couples. The court's decision in Obergefell struck down all state laws prohibiting same-sex marriage. Prior to Obergefell, the issue of same-sex marriage was a contentious one, with states having different laws on the matter. However, the Supreme Court's ruling has made same-sex marriage legal throughout the United States. States cannot discriminate against same-sex couples who wish to marry within their borders. Question 60. Scenario. Ms. Jessica Davis, a high school teacher in Illinois, assigns her students a reading about the Occupy Wall Street movement. The reading includes some criticism of the economic system and the role of big banks. A parent of one of Ms. Davis's students complains to the school principal, arguing that the assigned reading is biased and inappropriate for students. The principal instructs Ms. Davis to remove the reading from her curriculum. Question. Can the school principal restrict Ms. Davis from assigning a reading about the Occupy Wall Street movement in her class, even if the reading includes some criticism of the economic system? A. Yes, because the school principal has authority over the curriculum and can determine what materials are appropriate for classroom instruction. B. No, because Ms. Davis's right to academic freedom protects her choice of teaching materials as long as they are relevant to the course. C. Yes, because the reading could be seen as promoting a particular political viewpoint. D. No, but Ms. Davis must present a balanced viewpoint by also assigning readings that support the economic system. Correct answer. B. No, because Ms. Davis's right to academic freedom protects her choice of teaching materials as long as they are relevant to the course. Explanation. Teachers have academic freedom, which protects their right to choose instructional materials and methods. This right is not absolute, but schools must have a compelling reason to restrict a teacher's choice of materials. In this scenario, the school principal's concern about bias in the reading may not be enough to justify restricting Ms. Davis's right to academic freedom. As long as the reading is relevant to the curriculum and age appropriate for the students, Ms. Davis can likely assign it despite its critical perspective on the economic system. The Supreme Court case Keishian v. Board of Regents, 1967, established the concept of academic freedom for public school teachers. The court recognized that teachers have a right to select instructional materials without undue interference from school administrators. However, this right can be balanced with the school's legitimate interest in ensuring the curriculum is appropriate and meets educational standards. In Ms. Davis's case, the school principal would likely need to show that the reading is factually inaccurate, promotes violence, or is otherwise unsuitable for the classroom setting in order to restrict her from assigning it.